Hi, everyone. Thank you for joining. And we're very happy to have Dr. Catherine Briddick from the Refugee Studies Center, the Department of International Development at the University of Oxford in the UK, joining us. Thank you for joining us virtually, Dr. Briddick. And we've had more than a year-long seminar series, and today we'll explore a new aspect of this, which is the intersection of gender and migration. So we're very excited to hear you speak. So not only will we get this in on in live today, we're also recording the event. We'll put it up on our webpage, so others will have access to it offline as well. So okay, I'll turn it over to you.
Thank you very much for the invitation to speak today after what has been, I think, for many of us, a kind of a demanding term. I appreciate there are many calls on your time. So thank you very much for listening to me talk today about Cedaw and discrimination experienced in the context of migration control. So women are disadvantaged by migration law in a number of different ways. Disadvantage can be the product of rules or practices which explicitly treat women less favorably than men. So, for example, rules that prevent women's emigration. Usually, however, gender disadvantage flows from rules which appear on their face to be gender or sex neutral, but which actually disadvantage women or particular groups of women. This disadvantage can be expressive or material. It can entail stereotyping, the devaluation of women's work, loss of employment or other opportunities, and the confinement of women to certain roles and relationships. It can increase women's risk of experiencing violence, and it can simply be violent. Now, such rules and practices can be characterized as being unlawfully discriminatory by reference to national equality legislation or international law. Over the next 45 minutes, I'm going to be presenting research which examines the application of the UN Convention on the Elimination of All Forms of Discrimination Against Women, Cedaw. And I'm going to be asking two broad questions. Firstly, what does Cedaw's general prohibition of discrimination entail in the context of migration control? Put another way, what detailed obligations do states assume under Cedaw in relation to their migration control functions? And second, when rules and practices are challenged on the grounds of discrimination, what outcome do they have for the women who bring those challenges? In this second part of the research, then, I'm moving to look at the implementation of the standards that the Cedaw Committee has set. And I do that by reviewing individual complaints that are brought under Cedaw's optional protocol over a 9-year period. As will hopefully be apparent, this seminar, therefore, is rooted in a legal disciplinary approach to both discrimination and migration law. And I appreciate that many of the people joining me today are from a multidisciplinary program. So if you have any questions or comments as we go, please do ask them in the chat and stop me. It's much better to clarify a term or a concept as I unpack, hopefully, what will be my central argument. And it should enable us to have, hopefully, a more fruitful exchange of ideas at the end of the presentation. So I'm going to be focusing, as I said, on Cedaw, and I'm going to be examining the work of the treaty body, the Human Rights Treaty body, that oversees the convention's implementation, the Cedaw Committee. So I'm going to do three things. Firstly, I'm going to explain what discrimination against women is in international law. Secondly, I'm going to turn to discuss what the convention requires in the migration control context. And third, I'm going to examine the committee's applications of the obligations it has delineated to states. There are two parts of my argument. The first is that I'm going to identify doctrinal and empirical shortcomings in the committee's reasoning on when and why certain widespread migration control practices are unlawfully discriminatory. And second, when I turn to looking at individual communications brought under the convention's optional protocol, I'm going to reveal a particular kind of responsibility deficit, a deficit between determination and application, between how the committee approaches migrant women's rights in the abstract when discharging its general interpretive role, and when it behaves when confronted with a particular rule or practice that an individual alleges is discriminatory. So turning to the first of these, as may be apparent from the slide, I have primary school aged children, which means I do a lot of colouring in. So in front of you, you have the Article 1 definition of discrimination against women that's found right at the outset of the Cedaw Convention. And as you can see, this is an asymmetrical protection from discrimination. So unlike unlike CERD, for example, which defines and then prohibits any forms of discrimination on the grounds of race, Cedaw specifically protects women from discrimination. And at first glance, if we look at this definition, Cedaw seems ideally placed to respond to the discrimination that migrant women may be subject to. Article 1 encompasses both direct and indirect discrimination. It may therefore be relied on to challenge rules which are explicitly disadvantageous to women and those which negatively affect women or particular groups of women, even though they appear to be gender neutral. The wording that I have picked out in, I think it is yellow, any distinction, exclusion or restriction, which has the effect or purpose of moving into green, establishes adverse effect, whether or not that is intentional, as being the definition's crucial criterion. The breadth of the definition, and in particular, its reference to language that refers to public life, so the prohibition of discrimination that occurs in economic, social, cultural, civil, or any other field, enables the convention to norm fill, essentially, to provide a role in the convention that includes gender-based violence. That is violence that is directed against a woman because she is a woman or which affects women disproportionately. Now, states' migration control practices, such as pushbacks, for example, may involve violence or be violence, but there are other practices that states engage in, such as making people destitute, for example, or prohibited women from having recourse to certain state services, such as healthcare. These services may increase women's vulnerability to the violence that's perpetrated by non-state actors. Now, the Cedaw Committee's characterization as gender-based violence as a form of discrimination enables such rules and practices to be challenged, to be brought within the purview of the convention. Finally, Article 1 can be relied on to reinforce and complement two legal regimes which are crucial to international migration, but whose key instruments fail to define or prohibit sex or gender discrimination: the trafficking and international protection regimes. The definition also requires states to provide gender-sensitive interpretations of those instruments. Now, while the International Covenant on Civil and Political Rights, the ICCPR, and the Convention on the Elimination of All Forms of Racial Discrimination, CERD, differentiate between citizens and non-citizens, the Cedaw Committee is clear that the obligations of state parties apply without discrimination to both citizens and non-citizens, including refugees, asylum seekers, migrant workers and stateless persons within their territory or effective control, even if not situated within the territory. States parties are responsible for all their actions, the committee opines, whether or not the individual concerned is in their territory. Now, the Cedaw Committee, yes.
Catherine, sorry, a question. So who is in charge of enforcing these articles?
So the enforcement, yes. So the Cedaw Committee is the treaty body responsible for monitoring the application of the convention. Now, the Cedaw Committee has two roles. So one is the role I mentioned earlier. It hears individual complaints. So that's where individuals can allege that, for example, they have been discriminated against contrary to Article 1 of the convention. And the Cedaw Committee will adjudicate on that, much like an international court or tribunal, although it's not that. But the Cedaw Committee will also review reports of states. So states party to Cedaw have to produce information to the committee every 4 or 5 years to talk about how they've implemented the convention in their domestic law. And there's also a role for civil society there in pointing out or highlighting gaps in states' implementation of the convention. We might want to think about the Cedaw Committee as being a soft court. So it's not an international court or tribunal like the Inter-American Court, for example, but it has this monitoring and adjudicative role.
And how many states have signed into, complying or this convention?
So I think there are over 100 states parties to Cedaw. It's one of the most widely ratified of the conventions. So it's part of the International Bill of Rights, essentially. It's part of the kind of core framework for dealing with international human rights law and international rights abuses. The reason why I'm sounding hesitant is because while Cedaw has a really important role in international human rights law, it's also the most reserved treaty. So what that means is that states sign and ratify the convention, but they also enter reservations to particular parts of it, which means that they try and argue that either they shouldn't be bound by a particular provision, such as one concerned with equality in marriage, for example, or that they have a particularly or slightly different interpretation of it. So it's a convention that's ratified by states across the world, but it's also one of the conventions that states try and take almost like a pick and mix approach to. They're highly selective in the legal obligations they assume. Now, the reason why I've got this quote on the slide in front of you is because a number of human rights instruments in international law differentiate between the rights that accrue to citizens and the rights that accrue to migrants. And Cedaw takes a different approach. It takes a broad approach to both its beneficiary group and jurisdiction. So the rights that it provides should apply to women, whether they have a secure migration status in the country that they are in or whether they don't. And that's quite different from other international instruments. Cedaw's also establishing here an effects-based approach to jurisdiction. So it can protect or offers protection to individuals from harm that crosses state borders. So the provisional title of my talk today was, When Does Migration Law Discriminate Against Women? And I mentioned that the first part of the research was focusing on working out what states' obligations were under international human rights law in relation to their migration control functions. So Article 1 of Cedaw defines discrimination against women, and Article 2 of Cedaw prohibits it. And the committee that monitors it, the treaty body that I just mentioned, draws on Article 1 and 2 to impugn as unlawfully discriminatory a number of states' migration control practices. Now, in a moment, I'm going to talk to you about non-refoulement, the protection that's offered to individuals who can't be returned to their country of origin because, for example, they face serious forms of discrimination or harm, including gender-based violence. But in an article for the American Journal of International Law, I go into a lot more detail about the way that, for example, certain migration control practices which are widely used by states, for example, detention or pushback, are impugned by the committee as engaging its prohibition on discrimination. A number of rules which are very commonly found in, for example, British and US immigration law are also highlighted by the committee as engaging in indirect discrimination. And these are rules that, for example, make a migrant spouse dependent on their partner, or rules which mean that if someone wants to apply for refugee family reunion, they have to meet a certain minimum income requirement. Now, these rules on their face may appear to be gender neutral, but they have particular gendered consequences. So women might find it more difficult than men, for example, to meet minimum income requirements because of gender disadvantage in the labour market. And similarly, women who are placed or who are forced into relationships of dependency with an employer or a spouse may face an increased risk of being subject to violence. So the broader research project that I'm involved in goes through states' migration laws in a much more fine-grained way and identifies ways in which those rules are unlawfully discriminatory. We might, though, today be more interested in how the Cedaw Committee offers protections to refugees and those who are in need of international protection. Now, the Cedaw Committee has produced a general recommendation on the gender-related dimensions of refugee status, asylum, nationality, and the statelessness of women. Now, general recommendations are an interpretive tool. They're produced by the Cedaw Committee, and they aim to unpack the core rights that are protected by the Convention. They tell states essentially how they need to meet their legal obligations, and they can be relied on by individuals to understand when their rights have been violated and what the appropriate remedies may be. So I'm going to talk about the way that the Cedaw Committee has done some norm filling. Now, I've already mentioned that the Cedaw Committee's definition of discrimination against women includes gender-based violence. And I've said how this norm filling role was particularly important because key instruments in, for example, the international protection regime don't prohibit discrimination against women. But there are other gaps or absences in the international protection regime. So you might be very well familiar with the Article 1A2 definition of a refugee that can be found in the Convention relating to the status of refugees. And it states that individuals are refugees if they have a well-founded fear of being persecuted because, for example, of their nationality or their political opinion. Now, whilst nationality, political opinion, and race are all protected grounds in the Refugee Convention, there isn't a ground that relates to sex, gender, sexual orientation, or gender identity. And instead, individuals who seek to rely on the Refugee Convention have to bring their claim within the final ground that's set out in the Article 1A2 definition, that of particular social group. Now, I can talk for hours, and I'm not going to do so now, about the problems with the jurisprudence on the PSG ground. And in the Q&A, we might want to think about particular problems in the US context with the very restrictive interpretation that's used by US courts and tribunals, one which is very much out of step with international law. What's really important for us today, though, is the role that the Cedaw Committee has taken into arguing that states need to take a gender-sensitive approach to all of the Convention grounds, not just the PSG ground, but, for example, recognizing women's political activism and women's political agency and protecting, for example, feminist resistance to domestic violence or feminist resistance to trafficking as political opinions, and not just dealing with those cases under the PSG ground. And it's not just a gender-sensitive approach to credibility that states are required to take. It's about internal relocation and all aspects of the Refugee Convention definition as well. In addition to putting forward a gender-sensitive approach to the Refugee Convention, the Cedaw Committee goes into a lot of detail as to what refugee status determination should look like for women. And this is important because this is another gap in the article in the CSR. So the Refugee Convention tells us in Article 1A2 who a refugee is, but the Refugee Convention doesn't tell us how we should recognize refugees, doesn't tell us what rights refugees have when they're going through status determination. Do they have a right to a lawyer, for example? And what particular rights do vulnerable groups going through this process require? Now, this general recommendation makes it clear that protection-seeking women should have their claims determined by a system which is informed in every respect by a thorough understanding of discrimination and persecution on the grounds of sex and gender and the impacts of that treatment. And specific examples of this gender-sensitive approach would be, for example, requiring a woman to be interviewed by a caseworker who is also a woman and having a female interpreter present. It includes things like providing childcare and ensuring that victims of torture and sexual violence are referred to and receive appropriate psychosocial support. So these protections are really important to ensure that the gender-sensitive interpretation of the Convention is actually available to women who go through RSD processes. The core protection, though, General Recommendation 32, or this particular interpretation offers, is that women can use Cedaw and rely on Cedaw to argue that they should not be returned to situations where they face, for example, discrimination on the grounds of sex or gender-based violence. And Cedaw's protection from reform or from this return is broader than the protection that applies to refugees under the Refugee Convention. So Cedaw's expansive definition of discrimination can be used to identify unlawful discrimination against women at every stage in their journey from countries of origin to countries of destination and beyond. And Cedaw Committee recommendations, like the one that I've just talked you through, when applied indivisibly, establishes a set of mostly reinforcing obligations, which requires states to remedy discriminatory treatment against women. There are, however, a number of failures and a number of gaps and omissions in the committee's reasoning. So when it comes to indirect discrimination, for example, the committee doesn't tell women how they can evidence differential treatment. Do they have to do so on the basis of statistical evidence or not, for example? And crucially, the Cedaw Committee is silent on questions of justification. And this is really important from a discrimination law perspective, because states often assert particular rights as flowing from their sovereignty in the cases of migration control. They will have kind of very broad statements that the prerogatives of migration control requires things like detention, deportation, pushbacks, or a variety of other practices. Now, if these practices have disproportionate impacts on women, the legal question that we have to ask is whether these disproportionate impacts can be justified. And we need the committee to be really clear on the circumstances in which states are entitled to pursue those measures, and the circumstances where adverse effect, to use the language of US discrimination law, is not justifiable treatment, and therefore the state should change its policies. And I think if you're interested in kind of following this line of argument further, the Cedaw Committee has produced a general comment specifically on trafficking and global migration control. And this has a number of really significant gaps in it. And it essentially reads more like a policy statement than a legal tool that individuals could use if they have been trafficked, for example, to argue for their rights against states, or for those involved in civil society organizations to understand what, for example, a process that's able to identify victims of trafficking should look like. I'm now going to move to the kind of second part of my research and discuss Cedaw Committee jurisprudence. So this is about cases that are brought to the committee. And cases can be brought by individuals who are in countries which have signed up to Cedaw's optional protocol. And for this research, I reviewed 9 years worth of communications, and I identified 34 communications as concerning states' migration control practices. And the majority of these communications were found to be inadmissible. And I'll explain why some of that was in a moment. There were only 3 cases where a breach was found. Now, most of these cases came from just one country in Europe, Denmark, and more authors of communications were represented by one man than came from the remaining mostly European countries. All of these cases, or the majority of these cases, concerned non-refoulement, so the protection of women who argued that they should not be returned to countries where they faced discrimination, persecution, and gender-based violence. Now, these findings are significant for a number of reasons. The first I'm going to highlight is the fact that they do not represent the breadth of the committee's standard setting in relation to migration control. So both the committee's work on direct discrimination and indirect discrimination, its protection of migrant workers, for example, and its protections for people who are experiencing or at risk of gender-based violence, much of that is just absent from these communications. And instead, what we get if we look at Cedaw's work on migration control is a data set which is geographically skewed to particular European countries and which is substantively distorted. But there are 2 significant deficiencies in the way that the committee has approached issues around migration control. And the first is around its assessment of a communication's admissibility and the difference between admissibility and merits determination. And the second is that the committee adopts such a deferential standard of review in some of the cases it's called upon to decide that effectively fails to apply the obligations it has delineated. So when you bring a case before an international court or tribunal, you have to show that you meet certain admissibility requirements. You have to show that you have, for example, exhausted domestic remedies and that the thing that you're complaining about falls within the scope of the relevant convention. So when courts or human rights treaty bodies like the Cedaw Committee reviews individual communications, the assessment it goes through is often a 2-stage assessment. First, they have to ask themselves if a complaint is admissible. And then second, they move to considering its merits. Has there been a violation of the relevant right that's protected or rights that it's protected? Now, in the first set of cases that I've reviewed, the committee makes these points and decides these points sequentially and appropriately. In the second set of cases concerning non-reformor, the committee collapses these two questions into each other. And what that does is it leaves individuals who are concerned about reformor at risk of return to situations where they might be experiencing persecution or serious forms of gender-based violence. The second problem the committee has is around the standard of review that it applies, how it scrutinizes states' reasoning in asylum determination processes. And my concern here is that the committee adopts such a deferential standard of review that it fails to protect individuals who seek to rely on its obligations. So I'm going to talk about these two deficiencies in the analysis by drawing on 4 illustrative cases. So the first case that I want to talk about is RSAA versus Denmark. So RSAA was a Palestinian refugee. She was from Syria and she obtained a Jordanian passport following her marriage to a Jordanian man. She had 2 children. And she claimed international protection in Denmark on the grounds that she had experienced domestic violence and that her children were at risk of forced marriage. Now, all of these things are protected or should be within the purview of the Cedaw Convention. Her claim for asylum was, however, refused, primarily on credibility grounds, and her children's deportation was arranged. So the Cedaw Committee first looked at the admissibility of her complaint. And under the Cedaw Committee's optional protocol, Article 4.2, communication is admissible if it is properly founded and properly substantiated. Now, the committee reviewed her case and found that her communication was sufficiently substantiated. She'd been able to show them on a prima facie basis that her Cedaw protected rights had been violated. It then went on to consider the substance of her asylum claim, essentially, on a case-by-case basis, and it applied the correct merit standard of review, which I put on the slide in front of you. So the committee says that it's for the authorities of states parties to the convention to evaluate facts and evidence on the application of national law, unless it can be established that the evaluation was biased or based on gender stereotypes that constitute discrimination against women, was clearly arbitrary or amounted to a denial of justice. So when it's looking at how states determine asylum applications, how the state approached RSA's case, this is the standard of review that the treaty body is applying. So the Cedaw Committee looked at the facts in her asylum claim, and in particular, they looked at the way that she had been deemed incredible. They also looked at the structural barriers that she faced as a Jordanian individual, but somebody who was of Palestinian origin. So someone who was a refugee and had that history in the country where that she experienced gender-based violence. The committee held that she faced a real personal and foreseeable risk that as a woman who had knowingly fled her violent husband and had fled Jordan with her 2 minor daughters, was at risk of further gender-based violence. And the committee took an intersectional approach to the discrimination that she had faced in Jordan. And they found that Denmark hadn't accorded due weight to her status as a Palestinian refugee. Now, earlier on, I talked about General Recommendation 32, and I talked about the standards that the committee has set for how states should determine asylum applications. And when it was applying the standard of review to RSA's case, the committee found a number of ways in which Denmark had not properly applied General Recommendation 32. Essentially, Denmark had failed to meet its obligations under Cedaw, and the return of RSAA and her children would breach the convention. So what we have here is an example of somebody who makes a claim for international protection, who argues that they are a refugee under international law, but whose claim is not recognized by the state that she's in. and who relies therefore on Cedaw and the Cedaw Committee to prevent her deportation, to prevent her removal. And because her case involves gender-based violence, and because her case requires the monitoring body to take an intersectional approach to the violence and discrimination that she fears, she goes to the Cedaw Committee, which, as I hopefully have explained to you in the introduction to this talk, protects women who are refugees and doesn't discriminate between the rights that nationals and non-nationals should have. So should be an appropriate fora for this kind of complaint. And she's successful. Denmark cannot remove her. We don't know if she's recognized as a refugee as a consequence of this decision, but we know that she's not going to face, or we hope that she's not going to face, deportation to Jordan. Now, I want to contrast that case with one that was decided just a few months later. And it also concerned a case against Denmark, and it concerned a very similar factual situation. So this time, KIA was someone who had been resident in Denmark for her childhood, and she was tricked into leaving the country and forced into marriage. She was subjected to domestic and sexual violence for 11 years, and she eventually managed to escape and to return to Denmark, where she made a claim for refugee protection. And again, her history as someone who had Palestinian origins and the intersectional nature of the violence and discrimination that she experienced in Jordan were key parts of her claim. But the committee didn't reach the same decision in her case that it reached in the previous one I discussed. They found her communication inadmissible. And what they did was collapse the admissibility and merits reasoning. They applied to her and to her case a much higher standard of review. Her account was unsubstantiated because she couldn't show that her treatment was biased or based on gender stereotypes or arbitrary. So what these two cases show us is that the committee approached the situation confronted by two women who both faced quite similar and disturbing levels of domestic and sexual violence, but in two substantively different ways. And in the second situation, the committee collapses two distinct questions: the question of admissibility and the question of whether a right had been violated, in such a way as to preclude the merits being properly considered. And what that meant was that whilst RSAA and her children were protected from deportation, KIA and her children were not. So having exhausted the asylum determination process in Denmark, they risked reformal, potentially to gender-based violence and other forms of serious harm. They'd gone to an international soft court to have their rights vindicated, and instead those rights were not properly considered. So that's the first failure that I want to highlight about the way that the Cedaw Committee approaches some of the cases that come before it. I want to use two more cases now to show another failure. And this is similar to the first point I've made, but it is analytically distinct. It concerns the standard of review again, and it concerns how the Cedaw Committee approaches migrant women's rights, not in the abstract, when it's looking at general recommendations, but when confronted with alleged violations. So I have two cases that I want to discuss with you. And I want to do these cases to chart the contours of a particular kind of responsibility deficit. So the first case is from a few years ago now, from 2013. It concerned a woman who fled Burundi and claimed refugee protection on the grounds of political persecution. She was a member of an opposition party and had been involved as a political activist in a number of events and demonstrations. Now, while she was attempting to escape political violence, she was raped by more than one perpetrator at knife point. She went through the asylum process and her claim was rejected. Now, she then proceeds to take her case to the Cedaw Committee to argue that she should not be returned to Burundi. And her case is found to be inadmissible, but for a very striking reason. So MEN disclosed the sexual violence that she had been subject to, but she didn't describe that violence in her asylum interview as being discrimination. Instead, she believed that it was coincidental that she had been raped. Now, the Cedaw Committee said that because she phrased that part of her claim in that way, the state party, in this case Denmark, didn't have the opportunity to consider her allegations of gender-based violence. Now, this is a really astonishing decision for the committee to reach, because what they're saying is, and they say it very clearly on the face of this case, that describing having been raped at knife point by 3 men, but not defining that treatment as sex discrimination, is not sufficient to raise that treatment in your asylum claim. Her case was inadmissible, and we don't know whether or not she was subject to return. This case is interesting because it has a really strong dissenting opinion. And that dissenting opinion was written by someone called Dubravka Simonovic, who went on to become the UN Special Rapporteur against violence and women, its causes and consequences. And she rooted her dissenting opinion in General Recommendation 19 on gender-based violence, arguing that it was a matter of customary international law and international criminal law, as well as the Cedaw Committee's own work, that such sexual violence was discrimination against women and should have been considered properly in the case. So MEN is one example of the committee failing to apply its own standards in a really clear, and concrete, and easy to identify way. But I want to draw on a more recent case to make this point as well. And because I'm talking to you from Europe, I want to use this case to talk about some of the issues that are being confronted by refugees in Europe at the moment. And in particular, their return from one European country to another, where they've claimed asylum in one country, but traveled within the European Union. So at the moment, within the European Union, there is a system whereby an individual who claims asylum in one country, but then travels on and seeks international or other protection in another, if they are identified as having done that, will be returned under European Union law. And there are very few exceptions to this return. There are some that may be based on a family reunion, but in general, this way it's called responsibility sharing, but it's certainly not that, is a way of containing refugees in the first country that they claim asylum, and has a disproportionate impact on countries like Italy, for example, and Spain, who receive large numbers of individuals seeking international protection from across the Mediterranean. So Abdi Osman was someone who fled truly horrific torture and violence in Somalia. She was kidnapped by a member of Al-Shabaab. She was forced to marry the person who kidnapped her. Her father tried to protect her, and he was murdered in that incident. She was subjected to torture and sexual violence over a number of years. She became pregnant 3 times. And 2 of those pregnancies were ended in a forced abortion. And the 3rd child who was born was taken from her. She managed to escape and made the incredibly difficult, dangerous, and illegalized journey to Italy, where she was granted subsidiary protection. Now, in Italy, the treatment that she received did not meet the standards set out in General Recommendation 32. Ms. Abdi Osman was homeless for a number of years. She was detained. She wasn't offered protections as a survivor of sexual violence or a survivor of torture. She certainly wasn't offered any kind of psychosocial support or assistance. And she claimed that she should have been recognized as a refugee, but instead she was granted a lesser form of protection, complementary protection in the European Union. She formed a relationship and she wished to move and join her husband in Switzerland, another country in the European Union. She did so, and she made a claim for asylum there. That claim was refused, and she was returned under the Dublin III regulation, the system where individuals are returned to the first country they claimed in, to Italy. And when we talk about returns and deportation, that language often sanitizes processes which are incredibly violent and harmful to the individuals concerned. And we might be familiar with the violence of deportation in the sense of individuals being handcuffed and compelled into immigration detention or on a plane. This was a different type of violence because Ms. Abdi Osman was driven to the border. She was given a small amount of euros in cash, and she was left in a car park. And she was there in that car park with another group of refugees, and she lived on the streets for a period of days. She wasn't told where to go. She wasn't told what to do. She wasn't given any type of support or assistance by the state. She slowly made her way back to her husband, to Switzerland, and she became pregnant again. And again, she faces return to Italy. Her health by this point had deteriorated quite significantly. She brings a claim to the Cedaw Committee to try and opt out of this European system of compelling people to return from one country to another. And she does so on the basis that she's been subject to discrimination and violence, not only in her country of origin, but also in Italy, where she has been mistreated now on 2 occasions. The Cedaw Committee have the general recommendation that I talked you through in front of them. And Ms. Abdi Osman's legal representative takes them through all of the rights and protections that I described to you, and in particular, the support that should be accorded to sexual violence. Unaccountably, the committee, however, stated it is for the sovereign state party to determine the nature, structure, and procedures of its own asylum system. Moreover, they said it was unclear that Ms. Abdi Osman would face no specific indications that she would not be afforded protection in Italy. And it reached that decision despite the fact that, as I've explained to you, she didn't get the protection or healthcare that she was entitled to under the Cedaw Convention on not 1, but 2 occasions. So she can point to 2 examples in the past where her rights have been protected, and even doing so is not sufficient to offer her protection from return. Her case was denied. So this is another example of the Cedaw Committee just not applying, not enforcing the standards that it has identified as being necessary to protect refugee women from discrimination. And from a legal perspective, this is really problematic because the committee roots the general recommendation 32 obligations in that definition of discrimination against women that I started this seminar with. So this isn't presented as being an optional set of protections that individuals may be entitled to. The Cedaw Committee is saying that this is required by states as a matter of international law. And yet, when women seek to rely on those standards, the Cedaw Committee does not vindicate them. And what the decision in Ms. Abdi Osman's case does is leave a woman who has a significant set of health problems as a result of torture and sexual violence to be deported with a newborn baby to a country which has repeatedly failed to meet the standards the committee has set. Now, these 2 views that I've given you are not anomalous, but representative of others in which the committee's adoption of a general recommendation makes little discernible difference to its adjudication of communications that are brought to it. So I'm sure you'll be very pleased to know that I'm reaching the conclusions part of this paper. I think, and as I've hoped in the first couple of slides in this presentation to show you, that Cedaw is well placed to respond to discrimination against women that's experienced in the context of migration control. And there are a number of reasons for this. The definition of discrimination is capacious. As I've said, it covers both direct and indirect discrimination, including that which is violent, whether experienced in the public or private domain. The committee takes a broad effects-based approach to jurisdiction and its beneficiaries, which enables it, in theory, to hold states responsible for their extraterritorial and discriminatory conduct. And in its general recommendations, the committee has capitalized on this advantageous positioning, interpreting the convention robustly and impugning as discriminatory a range of laws and practices. It's also, as I hope to have highlighted, required states to make gender-sensitive determination procedures that apply gender-sensitive interpretations of core facets of the international protection regime, such as the Article 182 definition of a refugee. And more importantly, it enables or it urges states to increase women's ability to migrate safely and access protection lawfully. There are, however, significant flaws in the reasoning that the committee has employed in a number of instances. And I focused in its adjudication elements on non-refoulement and the protection that should be accorded to women who claim refugee protection. It's of concern that so few cases are brought to the committee alleging discrimination in migration control when the committee has engaged in such standard setting in this area. It's of concern that a number of states who have the laws and practices that the committee impugns are not being challenged before the Cedaw Committee by individuals affected by them. But when communications are brought, the committee's reasoning is disappointing and frequently unprincipled. And this is the case, notwithstanding the fact that in some of its decisions, the committee has given adjudicative expression to its commitment to respond to multiple and intersecting forms of discrimination and inequality. And I think the RSAA case I mentioned before is an example of that. It wasn't just the case that she was a woman who was at risk of gender discrimination. She was also unable to access equal protection of the law because she was a Palestinian refugee. So that's an intersectional approach being taken to the violence and the lack of protection available to her. However, there are a number of other cases in the data set that I examined where the committee takes an overly deferential approach to questions around state power and states' migration control functions. And this deferential approach seems to have two elements to it, either a failure to differentiate between admissibility and merits, or a failure to apply its own legal and normative standards. And in both of these examples, women complaining of discriminatory treatment are exposed to the risk of reform. So there's a wealth of research on the Cedaw Committee. So Loveday Hodson, for example, has said the committee has been unable to establish much of a voice on the asylum claims of vulnerable women. Alternatively, Bassat Cali, Catherine Costello, and Stuart Cullingham have said the committee has taken a tentative and deferential approach. I hope that you will have seen by now that my conclusions are much more scathing of the committee's actions in this regard. I think that their reasoning is unprincipled, and as a result of that, women's rights in the context of refugee protection go unrealized. The core kind of conclusion that I'm reaching in this research is that the committee needs to eliminate all forms of discrimination. It has to delineate the obligations with clarity and precision, and then it must hold states responsible for violating the standards it has itself set. So I appreciate that that was 45 minutes that was quite dense from a legal perspective, and that some of you may not be lawyers or have a background in international law. So if you have any questions at all about any of the material that I've covered, I'd be delighted to discuss them with you further.
I have a question. Can you see me?
Yes.
Yes, please do go ahead, and I can hear you wonderfully too.
Okay, great. So just thinking really practically about the US context, is the US one of the countries that is not a signatory of Cedaw? And I'm also thinking about how Trump also removed domestic violence as as characteristic of a particular kind of group-based discrimination. I'm just wondering if you can speak more to the US context here.
Yes, so there is something called the United Nations Treaty Depository, and I can share a link to that in the chat in a moment, and you can look up which states have signed and ratified Cedaw, and I'm afraid the US is a real outlier in this regard in being one of the few states that has not done that. Now, as I understand it, under US immigration law, individuals can seek withholding from removal on the basis of CAT, the Convention Against Torture. And so the Convention Against Torture is very similar to Cedaw in that it's a United Nations legal instrument that defines a particular kind of wrong and then protects individuals from either experiencing that in the country that they're in or being returned to that. So the US asylum system does engage with a very limited way with international law, with the Refugee Convention and with CAT, but it doesn't engage with Cedaw in the way that I've described. Could you repeat the second part of your question?
Oh, I guess just the other one was that, I guess I'm just thinking about always the tension between international law and like sovereignty questions, right? I'm thinking specifically about the Trump administration's decision to not count domestic violence as like under the definition of group-based discrimination, and how that changed like the ability for women to make claims for asylum. And then I'm thinking about like specific, some of the rumblings in the European Union about not just reservations to these clauses, but the ways in which they're just flouting them, entirely under the name, under the discourse of crisis or things like that. So I'm just wondering if you can speak to like, you know, the way that maybe some of the deferential posturing of Cedaw has to do with playing this game of trying to keep countries sort of on board on a day-to-day basis. Does that make sense?
I'm going to try and answer each of those in turn, and do let me know if I don't do so fully. So the first one was around the specific jurisprudence in the US around particular social groups. And I mentioned earlier that the US was an outlier in taking a very limited approach to the definition of what is a particular social group and seeking through various means to exclude women who are at risk of domestic violence from that definition, but also individuals who are at risk of gang-related violence as well. The common denominators here being that it's violence perpetrated by a non-state actor. And there are issues around how you define the particular social group, and the US's very restrictive approach to that question. But then there's a second set of questions about how you identify whether or not the state is willing to protect individuals from particular forms of violence. And again, within the US jurisprudence, as I understand it, there has been attempts to significantly increase what an applicant has to do to show that the state is not able to protect them. And the reason why I'm hedging all of my comments here is that this is very contested at the moment, that these cases are being litigated backwards and forwards. And there have been some quite notable successes in pushing back against some of these approaches. Nevertheless, I think that the core kind of consistent strand in US jurisprudence is a failure to recognize that women who are fleeing gender-based violence are refugees, both on the member of a particular social group ground, but also really importantly, potentially on the political opinion ground as well. I've come across one case which some wonderful students of mine from last year shared, which was a US case where resistance to domestic violence, feminist resistance to domestic violence, was interpreted as a political opinion. And that's something that has been litigated quite successfully in other jurisdictions, particularly, for example, in New Zealand and also within the EU. Now, if the US were to sign and ratify Cedaw, and if it were to use Cedaw as an interpretive tool, we might expect some improvements in that jurisprudence. But you alluded to a separate set of problems, which are those currently faced within the European Union and Council of Europe at the moment. And these don't go just to Cedaw, they go to something called the Istanbul Convention, which is the Council of Europe Convention on Violence and Discrimination Against Women. And this convention is really important because it embeds a lot of what Cedaw has done within the Council of Europe, but it also has specific articles in it which protect migrant and refugee women, including by offering them migration statuses and by ensuring some of the things that I've talked about in this talk are incorporated into states' national law, like gender-sensitive interpretations of the Refugee Convention. Now, a number of states have attempted to put reservations into those treaties or have unsigned them. All states have taken quite a negative approach to the convention. They've said a series of things about the way the convention protects intersectionally on the grounds of sexual orientation, for example, and use that as a pretext for not offering protection from violence. And I think this needs to be seen within a broader response to authoritarianism, and not just authoritarianism in Europe, but how we think about the role of international law in responding or countering some of the gendered impacts of the rise of authoritarianism in certain states. And that's something that many women who are being activist in Poland at the moment around changes to the law on abortion, for example, are having to contest on the streets while we talk about it in this classroom.
Thank you. I have some quite a few questions. So one is that, for example, is there, once the Cedaw has given its determination, is there a way to appeal? Then the other one is that I mean, given the difference that they have been reached in some of the cases, could that be explained, for example, in the initial representation that these women have had in maybe like access initially to like a lawyer or that they are aware of how they can bring the case. And then the other question that I have is that how is this committee formed, and then for how long? I mean, is it that some of the people that are part of the committee basically have some views, or they have evolved over time as well?
So on appeal, no, if the committee declares a decision inadmissible, there's no way to appeal that. You may be able to bring a case before another international body, another human rights treaty body, for example, like the committee that oversees the Convention on the Elimination of Race Discrimination, or before the CAT committee. Now, you're not allowed to bring cases before multiple human rights treaty bodies because that's precluded by admissibility requirements, but individuals do bring cases often to more than one. I think one of the things that's interesting to look at is why some human rights treaty bodies scrutinize state action more than others. And there is kind of an emerging strand in the research that indicates that the CAT committee is much more robust in protecting individuals' rights when they allege that they run the risk of being refooled. And that in comparison, the ICCPR, the Human Rights Committee, and the Cedaw Committee take a much less robust approach. And I think one of the things you might want to think about, although perhaps how you would design this research is an interesting question, is why committees which have quite similar standards of review, why some committees are much more deferential to states than others are. I think with CAT, the Convention Against Torture's definition of torture is very narrow in comparison with, for example, Cedaw's definition of gender-based violence. And so it may be that its precision and its focus and that narrowness enables the CAT committee to take a much more robust approach to states, whereas because Cedaw potentially offers much broader panoply of rights, it's therefore less assertive in enforcing them. I mean, we would have to think about whether that was the correct and principled legal approach, but that may be one reason why the Cedaw committee is more deferential. The other thing I wrote down was membership. So yes, members serve for particular periods of time. They are nominated, I cannot remember off the top of my head how long, I'm going to say 5 years, but we can check the relevant documents. So it will be set out in the convention in full how many years. Individuals are nominated by states to serve, but when you are there, you serve in your individual capacity as an expert. So you should not put forward, for example, your state's views on any particular problem. You sit as an independent individual who's hopefully either legally informed or legally rooted or has that background that would enable you to interpret the convention correctly. I'm sorry, I missed the third part of your question.
No, so I was thinking if, how they're treating the cases will differ either because their own background or that they're representing, or because it happens to have a composition that basically is more harsh than others in certain cases.
So I think that's a really interesting hypothesis, but I don't think that. I suspect that that's not the reason, simply because all human rights treaty bodies have very similar processes by which experts are nominated by states and then serve on committees.
And the fact that, I mean, how do the women access, help in order to bring their cases to the Cedaw? Is that
legal aid? Yes, you mentioned that. So again, that will depend on each state's national provisions. So within the European Union, a number of states and the UK, obviously not a member of the European Union now, do have provisions that enable individuals to receive legal advice and representation that's free of charge. And even when that's not available, there are a number of not-for-profit organizations who also provide that assistance. Interestingly, a number of the cases I reviewed are individuals who bring those cases representing themselves. And so the quality of legal advice, I think, is a real issue. I think you're absolutely right in pointing to that as being one of the reasons why some of these cases are not successful when they should be on their face.
And then I imagine that once you start the process, then, I mean, like the case that you shown that because it has not been set in a specific way, so therefore it has a certain consequence as well.
So now that may be a problem within some courts and tribunals, but it shouldn't be before a human rights treaty bodies who don't see individuals. So you don't litigate directly, you don't argue in Geneva or New York, for example, you don't stand at a lectern and explain how your rights have been violated. A lot of these cases are just decided on the basis of materials which are submitted to the committee, which the committee then reviews. And because the committee's procedures around evidence and how it makes decisions are fairly flexible, I think you are going to be kind of less disadvantaged as an individual representing yourself before a human rights treaty bodies potentially than before, for example, the Inter-American Court or the European Court of Human Rights. It's interesting as well that in a number of the cases from Denmark, legal representation was highlighted as being a problem. And I think the committee is rightly concerned that cases are just being brought to the Cedaw Committee where the individual concerned is not receiving the quality of legal advice and representation that they should. And I think I'll leave it that part there.
This is a really specific question, Catherine. Why do you pick 9 year for your data sets?
Do you know that that's simply the case that I was looking for a range of communications that would be both before and after the adoption of the particular general recommendations that I was interested in. So in the last decade, we have general recommendations adopted on trafficking, on asylum and refugee status, and gender-based violence. And so I wanted a number of communications to come from before and after the dates that those recommendations were adopted to see what the adoption of a recommendation, what difference that made to particular cases. And so 9 years just enabled me to do that and enabled me to read the kind of requisite volume of communications to be able to reach decisions. You could go back further, fairly obviously, and all of the conclusions that I have started to set out to you are premised on the fact that that's a limited data set, 9 years worth of cases.
Going back, sorry, to some of the point that I mentioned, I mean, do you know there how many times the committees change as well? I mean, there are like, if they were to be like 5 years, so sort of see 2 or 3 sort of set of committee just just to test the hypothesis that some composition might be sort of harsher to other ones of the committee.
So I think that information must be publicly available, you know, how long people served and when people joined and when people left. I think the 2 cases that I showed that concerned individuals who were Palestinian refugees who claimed asylum in Denmark, which were decided so close to each other, indicates that it's not the composition of the committee that's necessarily the problem. Because one would imagine that it was not necessarily entirely the same group of people sitting on the committee, but that there would be quite a significant overlap between the individuals sitting. Yeah. That's certainly an avenue that I could and should pursue. So thank you for suggesting it.
Any more questions in the room or in Zoom? No? I
have a question, if that's okay.
Yes.
Because I'm aware that I'm predominantly potentially speaking to an audience who are based in the US or potentially who are US citizens and are familiar with US immigration and nationality law. I would be interested in to what extent you find arguments based on international law interesting or compelling or relevant to your research and interests. Because if you're within Europe, kind of geographically rather than politically, these are arguments that you're very familiar with and that you would engage in potentially even before domestic tribunals. But I'm aware that that's not the case potentially for a number of you who may be involved in activism or litigation or research where international law potentially seems quite removed or not relevant to the types of arguments that you're interested in making.
I'm not a legal scholar, but I am a migration and border enforcement scholar. And I think I can speak first just as a US citizen to the way in which I think international law is still like broadly read as like an overstepping of sovereignty. I think that actually probably is the sort of sentiment on the street. And I think that that's growing in Europe too, right? But I'm also, but my research takes place in North Africa and in West Africa, where international law is often viewed as sort of just an extension of a colonial like imposition, and particularly around issues of gender, right? Like you have such different interpretations of what constitutes violence, you know, all that bundle of issues around gender. And then also, you know, if we're thinking about international courts, you know, we're thinking about, you know, who gets prosecuted in those courts. They're mostly like post-colonial leaders. And so there is a lot of resistance. I think there's both at the state level, a diplomatic and geopolitical motivation to participate in these conventions, but there's also like a deep-seated suspicion and resistance against them to the you know, to the end that some of the African countries have formed their own court, right? Like, so yeah, so it's complicated, I think.
I mean, one of the cases I excluded from the sample was a woman who got recognized as a refugee in the UK, but then brought a case against Libya for the gender-based violence that she had experienced there as a feminist activist. So I would say that it's not entirely the case that international law is kind of viewed with suspicion in those instances, because this was an example of somebody who, when they got to a jurisdiction of safety, one of the first things they did was bring a case against the country that they had fled from to argue that their international legally protected rights had been violated. And interestingly, that case was entirely successful. And so that kind of speaks to your research, but I think it also reflects on some of the things that I've been talking about, which is when somebody is recognized as a refugee and they're bringing a case about the state that they have fled from, the Cedaw Committee can recognize that and find the violations. But when individuals are bringing cases against refugee receiving states for violations of their rights, the Cedaw Committee is less able to recognize that and to vindicate those rights in the migration control context.
Yeah, the other thing is that, I guess, I mean, when you ask the question to the people attending this seminar, probably it's not representative of what the majority of the US people are thinking about, because, yeah, as you said, in other countries, you think, international law sort of protecting you, or some of the last resort of some of the protection of rights, then is thought more like an invasion of their own sovereignty.
Yeah, that matches my intuition as well, that I think a lot of people that are sort of already have an anti-migrant, anti-refugee disposition also have a deep skepticism of international law writ large. And so I think sort of, it seems to me that, like, in at least the US political context, that I don't think international migration law is like seen as a lever likely to change a lot of things, I guess.
Well, if I could follow up too on the Libya example, I think, like, from the North African context, the fact that that woman's case was adjudicated against Libya and not against, you know, the European Union or Italy for initiating the pushbacks, you know, like pushbacks or arming, you know, Libyan defense or militias, or, you know, all of that, like creating those particular contexts, I think sort of underscores the point that people feel like a suspicion, right, of international law as still really serving European interests or Euro-American interests over, you know, over global interests, or being selective about those, maybe would be the.
And I think, yeah, I would agree with the broad thrust of that analysis. And I think that the case I talked about towards the end, Ms. Abdi Osman's case, is a perfect example of that, because a European system which was predicated in deterrence, which was predicated in containing refugees in particular areas in Europe, which, as I said, when I kind of went through the facts of that case in a lot of detail, because I wanted to really make the point that on 2 occasions, all of these rights protected by Cedaw had been violated, and yet the committee says we have no evidence that if she's going to be returned, she would face those violations. Thinking, well, what do they need then actually under those circumstances? What possibly could she have presented to them? And so we might see that case as an example of migration control imperatives within the European Union, and this particular EU model of returning individuals to the first country where they've claimed asylum being vindicated by the committee in this respect, because there's no challenge available to her. She can't, or it's very difficult for her to do so through European Union mechanisms. And the one mechanism we might think should be available to her as someone who's experienced sexual violence and torture and gender-based violence, Cedaw, the committee doesn't take the role that has been given to it in international law. And I think that's really troubling. When I discuss this research, I'm normally discussing it in countries where individuals have the opportunity to use the mechanisms that I'm talking about. And so it's very different when I speak to you because it's much more abstract, potentially, depending on where you might go and work after your studies here. And so that often kind of presents a particular kind of conflict for me, because a lot of the time I will point to particular things in states and say, look, the Cedaw Committee has impugned as discriminatory. So when I talk to legal activists, I'll say, why don't you bring a case? There's really clear recommendations on this point. And you have, for example, a group of individuals who require protection. So you should consider this international remedy. So on the one hand, sometimes when I'm talking to audiences, I say, use the remedy, but it has this problem. Whereas when I'm talking to you, I can't even say, use the remedy. I'm painting a picture of an international regime that has potentially only tangential interest to you or tangential impact on the work that you may be doing.
There is a question on the chat about how, if the gender and COVID-19 guidance from international bodies has resulted in any shift in policies, because the problems on the ground on gender are very real.
Ask about how guidance initiated in policies. Yes, I don't know a Cedaw-rooted answer to that question, other than that the convention protects equal access to healthcare and maternity services, for example. And there has been successful litigation where women's rights, for example, to healthcare around having healthy children was denied, particularly on intersectional grounds such as race and being a member of an indigenous group. There's kind of some really interesting jurisprudence of the Cedaw Committee on that. It doesn't relate to COVID-19 though. The only specific guidance I can think of would be from UNHCR, which has like a data portal where it's produced kind of an analysis of either restrictive or non-restrictive measures adopted by states in relation to COVID-19, because we're aware that the pandemic is used by states as an opportunity to kind of entrench or further entrench policies of immobility. I agree that presents a series of issues around gender, and particularly in relation to gender-based violence, but I can't think of a kind of clear document or source that I can point you to. I've got Sarah's question now, and they're characteristically challenging, so thank you for that. So have there been any interaction between the committee's reasoning, the European Court of Human Rights, and other treaty bodies? And there has been. So the European Court of Human Rights regularly refers to the work of the Cedaw Committee in its cases on violence and discrimination against women. And there are kind of certain key cases, such as Opus versus Turkey, for example, where the court defers to the Cedaw Committee's definition of violence and discrimination against women and says that Cedaw is the specialist legal regime that regional courts should turn to when adjudicating on, for example, Article 14 non-discrimination cases involving gender-based violence. Has there, though, been any interaction here when we think about challenges to Dublin returns? Because you're right, Abdi Osman is very similar to a number of cases where individuals have gone to the European Court of Human Rights to challenge their removal from one EU country to another. And what they've normally done is relied on Article 3, which is the prohibition of torture, inhuman and degrading treatment. And we might want to think about why Ms. Abdi Osman brought a case to the Cedaw Committee and not to the European Court of Human Rights. And I don't know the answer to that. I think it's interesting to think about, if you have more than one international court or tribunal to go to, why you would choose a UN treaty body and not a regional court. It may well be that the court's reasoning is so restrictive when it comes to things like Dublin returns that she thought that the Cedaw Committee, because her case was so involved gender-based violence in every point of her journey, and was so kind of it's almost hard to approach it without that kind of non-discrimination gender-based violence lens, that she thought the Cedaw Committee would vindicate her rights more than the European Court would do. But you're absolutely right to point to those cases at the European Court of Justice and at the European Court of Human Rights. And obviously MSS is one and Tarakel is another, where you see the two courts engaged in a kind of transnational conversation about the circumstances in which individuals can be returned to either Italy or Greece and the treatment that they would face there. The committee does not draw on any of that discussion. It does recount kind of paragraph after paragraph of kind of NGO evidence about the treatment of asylum seekers in Italy, but then it doesn't, again, link that to its general recommendation on the treatment of asylum seekers and refugees. So again, there's just this mismatch. And I would agree entirely that in returns to Italy, violations are only very rarely found. In comparison with returns to Greece, although the standard of treatment was quite similar in the two cases.
Okay, so thank you very much, Dr. Briddick. So if you join me as well, and so hopefully at another time we might be able to have you here around. And this is our last seminar for the fall, and we'll see you back in the spring next year. Thank you very much then.